and just start oh, there we go. Got it. Could you just go ahead and start do a roll call?
Certainly, Madam Chair. Ms. Dawson.
Present.
Ms. Evans.
Here.
Yep. Mr. Geffen. Mr. Geffen. Someone's on vacation. Mr. Urban.
Present.
Ms. Kaser.
Present.
Judge Kulik.
Present.
Mr. Page. Mr. Page. Representative Robbins.
Present.
Thank you. And Ms. Sherlock. Ms. Sherlock. And I see, Madam Chair, that Mr. Page is coming in, so I'll mark him as present. So in that case, we have 7 of the 9 members present. A quorum is present, or excuse me, 8 members present.
All right.
7 of the 8, yes.
All right. So just want to note the June 7th meeting minutes have been posted to the task force website. So if anybody has any corrections, additions, edits, whatever they may be, please let us know. Hearing no corrections, the meeting minutes are approved. All right, so last time around, we were still going through the list. We're still on the 15-year disqualification, so the felony level disqualification list crime. And I did, unfortunately, I did not have the document that Chair Geffen was working from, but I did at least have the document that I had done for the time before. And so I went ahead and filled in, well, to be fair, I had a law clerk fill in the remaining crimes, and I did ask Will to send that out. So even if people have not had a chance to look through it in real detail, I think that'll be just helpful for us to maybe even knock the rest of these 15-year disqualification crimes out of the way today. And if you could bear with me for a second, I shut my dog out of my office and she's really unhappy with me. Hold on, sorry. All right, sorry about that, everybody. So I have a Velcro dog. So wherever I go, she goes. All right, so what I'm gonna try to do is, I know I emailed it out, but I think it's just easy to share the screen so we're all looking at the same stuff. So I'm going to attempt to do that.
Recording in progress.
Oh wait, hold on, sorry, I need to save it to my desktop. I know what I'm doing wrong. I only have it open as a read only at the moment. Sorry, everybody. Sorry, everybody. It'd help if I save the right document to my desktop. All right, I will try again. Share. All right, we can see it. I shared the right document. Okay, perfect. Sorry, I'm guilty of having a lot of documents open at the same time, and my desktop has a bunch of stuff on it too that I probably should not be sharing. So, all right, I'm going to scroll. Last time, I'm just scrolling here quickly. Sorry if it gives people motion sickness. Last time I think we're finishing up. I think we had finished with 3rd degree. I don't know. I thought we had. If anybody thinks we were still talking about arson in the 3rd degree, let me know. All right. I'm not hearing anything, so if anybody's raising their hand, I must be missing it. Then I thought today just start with burglary. So burglary is one, kind of the basic elements is essentially somebody who enters a building without consent with the intent to commit a crime or commits a crime while in the building. So burglary does have 1st, 2nd, 3rd, and 4th degrees. There can be varying elements to it. So I guess just started off the conversation right away. people thinking this is a person crime or a person or property? And I will edit it out. Judge Kulik, thank you for speaking up.
Great. Well, I've got my my book opened.
You brought it.
To 6095. I'm going to go back to 82. Huge difference in burglary, because a first degree burglary is a dwelling. That is someone's home. And when you enter without consent, with no right to be present, it also includes committing a separate crime while in there, or intending to commit a second crime. And because it's a dwelling, that's a necessary element. It's definitely a person crime, as opposed to when you get down to, going into a shed that is clearly not a dwelling. People don't live in it, and you're going to steal a chainsaw. That's more a property crime.
So I would say if we said it's a person, probably one of the person / property, where it kind of depends on what is happening.
Well, yes, and I think a breakdown would be really helpful, since burglary has several degrees. And I'm just looking here.
First, you said was
A first degree is definitely a person crime, because it is
It's like first degree burglary of an occupied dwelling.
exactly. So burglary in the first degree is entering a building without consent with intent to commit a crime, or enters a building without consent and commits a crime while in the building. And the building is a dwelling.
okay.
And another person, not an accomplice, is present when the burglar enters, or at any time while the burglar is in the building. Second degree is just a building, but not a dwelling. It also is without consent with intent to commit a crime.
Does the second degree require somebody else to be present?
Let's see, I'll read the whole thing. Burglary in the second degree, whoever enters a building without consent and with intent to commit a crime, or enters a building without consent and commits a crime while in the building, either directly or as an accomplice, commits burglary in the second degree and may be sentenced to imprisonment of not more than 10 years or to a payment of a fine. Oh, yeah, I take that back. The building is a dwelling but not occupied. Remember, first degree,
okay,
there has to be a non-accomplice occupant in, and second degree is still, I would argue, a person crime, because, well, you'll have to decide. No one is present, but it is a dwelling.
okay.
Whereas third degree, it is a building and not a dwelling.
Yeah, I would say if we're gonna call like identity theft one of those like bordering crimes, then first degree burglary is as well. And so we have like this third category, like violent crime, property crime, and then this kind of third category of bad crime. It's really hard for me to like get on board with that though. My girlfriend went to prison for 72 months for breaking into cars in a parking garage of an apartment building. They called it first degree burglary of an occupied dwelling because it was attached to an apartment building, like the underneath of car parking garage. And so again,
Okay, the problem is that when you've been the victim of a crime, even a property crime, it is a terrible feeling. I've had my car window smashed a few times and my purse taken out of there or whatever. And victims are always victimized. But I mean, at what point, because it makes me feel violated and awful, it still doesn't make it a person crime per se. I mean, if someone steals my identity or even just steals the cash out of my wallet, that is definitely, that might even be a crime of poverty, but I still feel violated. So what do we do about that whole gray area and that slippery slope? There are certainly crimes that are, there's no debate. We know they are person
and
crimes.
if we were arguing for sentencing changes, if we were arguing for that, it would be a completely different conversation. But we're arguing for when someone, after they've been a certain amount of time for, from when these crimes have been committed, when are they ready to return to work? Like, this is a different conversation, right?
Right, understood, except that we're doing a little bit of that because there's got to be a reason we are categorizing some of them as person crimes, some as property crimes. And I'm assuming it's because person crimes are more troublesome. I mean, they're more troublesome because the victims are truly more victimized. We worry about people's safety if you're going to be around vulnerable people. And it's not just stuff, it's now people. And so there is a reason we're categorizing. And my point is, all crimes make victims feel rotten, but I don't know that certain things rise to the level of being called a person crime just because they make victims feel really violated.
I think that's fair. And Judge Kulik, before we go too far on this, 4th degree, remind us what 4th degree is, since you have your handy little book.
I do. I've got my book in front of me. And burglary in the 4th degree, whoever enters a building without consent and with intent to commit a misdemeanor other than to steal, or enters a building without consent and commits a misdemeanor other than to steal while in the building, either directly or as an accomplice, commits burglary in the 4th degree and may be sentenced to imprisonment for not more than 1 year or to payment of a fine of not more than $3,000 or both. And if you're wondering what kind of misdemeanor you might commit that would not be theft, it could be vandalism. Just as a for instance.
So that one's a gross misdemeanor if I caught that on the tail end? And not
Yeah.
more than 1 year?
Right, it is a gross misdemeanor.
Okay. No, and the burglary one, and I can just sort of continue the conversation, is interesting to me. I definitely can see the dwelling because that's supposed to be your safe place versus, for example, I had had clients over the years. I had one who broke into an abandoned bank as teenagers and they ate pizza and spray painted the walls. And I had another one who went onto a construction site and stole tools. I mean, nobody was there, nobody was around. These were all after hours, completely empty, but yet technically it's burglary. And so those to me, I think again, I'm not saying these are not serious crimes. The legislature has deemed them to be felonies, but I do definitely think burglary is one where at least I'd question the perhaps 3rd and 4th on a 15-year list for sure. I guess if I start that off there, I don't know how other people feel. Gina, you're muted. I don't know if you're.
I am. That story of my life. 4th would already be only 10,
4th,
right? Because
yeah, you're right.
So
Yeah. Although I think our statute I guess our statute specifically says felony level. And I haven't gone to look actually because we haven't gotten to the 10-year to see if 4th degree burglary is on the 10-year list. I haven't looked that far yet. So I will be upfront about that. So I can even volunteer that I raise a question about 3rd degree being. There we go. Throw myself out there. So I guess then moving on, possession of burglary tools. Again, I guess I would call it property. I don't know what other people think. Not hearing any objection.
Call it property.
All right.
I have a question. I'm sorry. So possession of burglary tools, couldn't that be used to tie someone up? I don't know what the definition of tools is, but certainly zip ties or things like that could be used to harm a person. So
yeah, the burglar, at least the way I've seen it, it can be it's a very broad definition, if I remember correctly. I mean, it can be your everyday use of items or it can be specific items. So it can be broadly used.
Yeah, it's generally like crowbars and.
That's usually when I've had it, at least, prosecutors telling me I'm gonna add it, is client had a crowbar or something, even if they're different. areas.
Yeah, and it's the people that I know that have gotten them are people that have previous burglary charges, or it's on top of a burglary, like they got charged with the burglary and then they charge them with the possession of burglary tools as well.
Yeah, I agree. I've usually at least seen it used where it's a companion to the burglary, or they've had the prior burglary type offenses.
I don't know if you can see it, Lucas. Judge Kulik's got.
Oh, I'm sorry, I didn't see it. Thank you.
And that's okay. I'm just trying to be polite here. Maybe point of interest. I have never seen burglary tools charged unless, that might be used as for an assault, for instance. So unless a prosecutor could argue that the zip ties somehow enabled a person to illegally enter that building, then they're not really a burglary tool. Interestingly, there's a big court case about a big padded leather glove because it was used to successfully smash a window so that someone could reach through and get it. So it's any tool that can be used to help you illegally access the building. So, and not tools for that are used in other crimes like kidnapping and assault.
Dave, I see your hand.
Yeah, so we had a guy at Teen Challenge whose background study was taking a long time, and then it came back that he needed supervision, and I looked at his record and he was charged with burglary tools. So I went and asked him if I could help him, what his issues were. He had a meth addiction and he went from county to county, and his burglary tool was a coat hanger, and he would use it to stick it up a vending machine and take all the quarters out and go buy his meth. And then when he would get caught in that county, they would charge him with possession of burglary tools. He would get a misdemeanor, he would go to the next county. So he was charged in 7 or 8 different counties for the same thing while he was supporting his meth habit. So it wasn't really a crime against a person. And it wasn't something that he was intending to use to break into a building with, but it certainly was a burglary tool.
And I think, and this is where I wish I had Chair Giffen's notes, but I don't know what people think about this one as essentially a disqualifier, similar to I think when we were having the possession of shoplifting gear conversation, there was some conversation surrounding, is that really a disqualifying offense? Does that serve the public safety? So I guess same question here, partially just because of the similarity of the offenses. What do people think?
Well, what troubles me is when I think about, I have a hammer in my drawer in my office right now.
Me too.
I do. And that's because I don't call maintenance people if I want something put on the window, and you never know. It's a handy tool, but it also could be a burglary tool, like those zip ties, like the coat hanger. Unless it's in conjunction with another charge, just having household items isn't enough for me to say that one alone, standing alone, should disqualify you for anything. If you've ever run for office, you got a trunk full of zip ties because you are putting up those signs. I know, been there. And I have junk drawers full of them. So that's why I just have a problem with the tools part. The shoplifting tools are burglary tools. As standalone, they don't mean a thing because they are normal items that everybody probably owns, even crowbars. However, if it's in conjunction with another more serious crime, we got the more serious crime. That's the one that we're worried about. It's the burglary in the first degree. It's the assault.
I'm in total agreement with that, Judge.
Me too. It sounds completely logical and reasonable.
No, and I think that that makes sense. And I think that's similar kind of along the lines of what we've expressed about other similar charges where, and again, the legislature has set these out as statute, you know, as a crime. But again, we're still looking at not every crime as a disqualifying offense. And so what's that relation to public safety? Okay, so I'm just gonna keep plugging away unless somebody yells. So I will stop if I hear somebody yelling or you raise a hand. But moving along to insurance fraud, this is essentially attempting to divert, collect, embezzle funds from an insurance type scenario. Putting it out there right away, to me, I guess I understand maybe there could be a personal victim involved, but to me, it's a property crime. I don't know what other people think. Judge
Well,
Booth?
it's a property crime. And maybe another subcommittee is going to be looking at this, but my only concern with this is not your ability to open a daycare, but applying for public funds to run the operation, for instance. So I am only concerned if you've got a history of this, of handling somebody else's money or even applying for funds, but not taking care of people. Because I think that's one of the reasons that we're separating these out. Financial crimes might be crimes of poverty, might just be financial crimes of greed, frankly. But, and there are certain positions that I wouldn't want that person to have, but they're totally unrelated to their ability to care for people.
Dave?
Well, that's a good point. If there's not an automatic disqualifier, certainly for 15 years, and somebody that, like you just explained, Judge, was using this to defraud people, then the DHS person who's reviewing the background study has the right at that time to disqualify them, but it shouldn't be an automatic disqualifier for 15 years.
Okay.
I agree with that.
Thank you. Sorry. I just wanted to push back on that a little bit. My aunt has been cared for in an assisted living facility, and she's had cash stolen out of her wallet, other items stolen multiple times in the last year. So I think even though people are caring for her, they're also stealing from her. And I think it's a real issue.
No, and I think that that's good. And definitely it's always good to hear the other perspective, and especially from people who have experienced that. And I don't know, and I guess, well, I suppose the hard part then is that's the point when definitely, I suppose it's a matter of proving it. Because if those are getting reported and if law enforcement can figure out who did it, then that's the person, in this, I guess, not necessarily a little bit of pushback, that's the person who should be disqualified versus, let's say, the person who did do it, but actually is rehabilitated and not doing that anymore. So I don't know what other people have thoughts.
I agree with Representative Robbins that, for instance, and it goes license by license. I think it's necessary to be licensed to be a non-relative guardian or conservator, because there not only are you making decisions for that vulnerable adults, livelihood and where they reside, and making sure that their needs are met, but you're also handling their money. And anytime that you're handling somebody else's money, including government money, I think those are the jobs specifically where somebody should be disqualified. Where if it's working with people where you don't have access to their money, that's something else, but that's a job by job basis. But yeah, there are jobs working with the elderly where you would have access to their money, and I would be concerned too.
Well, and I think that's where, like, I know in the remedies subcommittee, we have proposed looking at disqualifications differently based on who's actually receiving the care, because right now the statute just lumps everything together. So that's definitely something that the remedies subcommittee has looked at. All right, so moving on, the aggravated forgery. This is altering a writing or an object. Essentially, you're altering documents and with the intent to defraud it. So I would assume there's some sort of a monetary gain or something along those lines. Obviously, these are, as I warned the very first meeting, the Cliff Notes version. All right, so aggravated forgery, person or property?
Property.
Okay. And I guess similar, this might sort of follow the conversation from the insurance fraud, but what do people think? What are thoughts on this one as far as a disqualification, a shorter time, different use depending on who you're serving? I guess what are people's thoughts?
Specific to the license, but for those that don't involve, again, the handling of money or maybe the creation of important legal documents, I'm not sure what that would be. Absent those, I don't see the necessity for a 15-year on that one. As long as we're talking about a licensure for something where there's no risk of a repeat offense because there's some opportunity.
Okay. Anybody else? No, if not, that's okay. All right, then we'll just keep plugging away here. So forgery is the next one down. Again, it's similar concept. So intent to defraud, making a label or so this is more, if I'm understanding this one correctly, forging the document. So false writing for identification, stamp or merchandise, alters a membership card. What are people's thoughts? And Ms. Kaser, I see your hand.
Yeah, I just kind of had that question of like, really, what's the difference between an aggravated forgery versus forgery, which is next we have check forgery. I mean, they kind of have some similarities. And so I'm just not knowing, I'm just kind of curious what makes them different.
No, and that's a good question. And that's where definitely the Cliff Notes version can be a little difficult. And I'm scanning here quickly too.
Because if they're really not any different, I would say then the same principle applies, that maybe for those areas that handle funds or others, we would say it might be a DQ, but for others, it wouldn't be a DQ. But
and I think that's kind of, I mean, this is similar to, I feel like there was another whole section that we all did where they were all very similar and we kind of cut and pasted along those. I think your assessment is probably pretty spot on in my opinion. I don't know about others, but I can definitely, I mean, to me, I think that makes sense. But yeah, they're all kind of those forgery type. You're obtaining something by false pretenses, some sort of, whether it's altering a document, issuing a forged check, something along those lines. So I would agree. So anybody object if I do also just moving on property for number 41, and similar to what we've said, where it's really looking at a disqualification for those that handle funds or important documents?
I just wanted to give people a little bit of information on what makes it aggravated. So you saw in the regular forgery, it can be a membership card, you know, something like that. But the aggravated, it's a higher level involving, as an example, misuse of an official seal or seal of a corporation, public record or official authentication or certification. So you create a fake certified document for purposes of, committing a fraudulent act, and usually involves money or property. Or you even give a fake notary stamp. But I mean, so more sophisticated uses that use fake official documents, and so those are the aggravating factors. It's not the gym membership. It's a more serious misuse in writing to obtain property or money by fraud.
That's helpful. Thank you very much. And then even moving along, number 42, we've got obtaining a signature by false pretense. So you're obtaining a signature essentially by some sort of false information, something along those lines. But I guess I would, similar to what Ms. Kaser just said, definitely a property crime. Now, I guess I'm happy to add disqualification again for those that handle funds or important documents, so that somebody's not stealing the identity of your aunt in the nursing home or grandma or somebody along those lines and then going out and doing a whole bunch with that. Any objections there? No? All right. We're moving right through this, everybody. So then dangerous weapons. So this is pointing a gun toward another, loaded or unloaded, recklessly handling a gun or dangerous weapon for discharge, manufacturing metal knuckles or switchblades, possessing other dangerous articles for unlawful use, furnishing a child under the age of 14 with a firearm. So I guess, what do people think? Person, property?
Person.
I don't know what I was thinking too. And then just the cliff notes here, some felony under some circumstances, not all. So I definitely, I mean, again, I think this goes to some of those other more serious ones where we have obviously the possibility of great bodily harm or death from a violation of this statute, which of course would be very concerning. Any other comments for this one? Nope. Okay. Machine guns and short barrel shotguns. So the accused owns, possesses, or operates a machine gun. Person or property?
Person.
And I guess we're all, I think this one, you can all understand again why it's there. So moving on then, adulteration. So this is one where you're causing death, bodily harm, or illness when you're altering a substance.
Like the Tylenol from years ago.
Yes. That's exactly what person. I guess, what are people's thoughts? This one to me really struck me as more so almost not even when somebody's using or handling funds, but they're the individual passing out the medication, or I guess I see a concern with that. Any other thoughts, any other comments on that? To me, it's almost the opposite of what those forgery concerns were.
Right, I agree. That's the sort of crime that's really really frightening, and yeah, that flies in the face of caring for any vulnerable population.
Yeah, it seems to me that this type of crime is premeditated. It's not always focused. In fact, it's more general. It's just somebody who has a disregard of others and life, and This would be something I would finally support on this list as being a disqualifier.
Well, and I think to me, what strikes me so much is it's the intentional adding of that substance. So this isn't you accidentally, did this. And I think, especially with the overdoses and, people are being sold drugs, they don't know what's in them. And then the concern that person could go have access to, I really especially think about, the nursing homes and the long, assisted care facilities where there's so much medication and people really do rely on others for their daily living. All right, so riot. So this is, what do people think about this one? I mean, and I'll just sort of speak up here with, I know at least our office saw a lot of these calls with the George Floyd and so with the Derek Chauvin and the Kim Potter, all the rioting from all of that, our office saw a lot of these charges coming through where, so of course, people very unhappy with what's going on and with what's happening, and they were getting charged with riot. So I'll just, at least that's what we saw quite a bit in our office recently.
I suspect that the difference between rioting or protesting or just being, community involved or being a community activist are a very fine line, and makes a difference probably what color skin you have, to be really honest.
Well, this riot involves intentional acts of force or violence or threats of force or violence. So those are independent crimes themselves, assault or terroristic threats. Protest is, I see it as peaceful. Now, government response to protest is not always peaceful, but protest is peaceful and it doesn't involve assault or terroristic threats. And it's constitutionally protected as free speech and assembly. So is there gray area? Sure. But I frankly don't even like this one called riot, because an assault is an assault is an assault. And you got somebody on assault. And terroristic threats is a threat of violence. Same thing. Two or more together and suddenly it's a different crime. It seems a little odd. I've never seen it charged that way. Of course, maybe we just haven't had any riots up here in Mille Lacs County, but.
And Max, I see your hand.
Thanks. Yeah. So the different degrees of riot matter quite a bit. Riot in the first degree involves the death of another individual, so that's obviously a person crime. Riot in the second degree involves people who are armed with dangerous weapons. Again, that seems like threatening behavior towards other people and seems like a person crime to me. Riot in the third degree, I think would qualify as both depending on how it is applied. It can be a person or property crime depending on how the threat of unlawful force or violence is used. That would be how I would classify each of those.
Oh, and that's definitely very helpful. And I think, because just on its face, riot, I suppose, raises the question of, is that really something that would be a disqualifying offense just on its face? But when you break them down, first degree where there's a death of another individual, second degree armed with a dangerous weapon, I think some of those are of course concerning. So I guess, is this the type of crime where it is a disqualifying offense or a shorter period? Does 15 years make sense? I think our group has really sort of looked at, does the 15 years even make sense, period? But just, what are people's thoughts on that?
I mean, I don't have huge concerns about riot in a third degree being excluded from a 15-year or lengthier period, but riot in the first and second degree involve multiple people who are armed with a dangerous weapon, who are making threats to other people or to damage property. And that is behavior that is extremely concerning to me. I can't assign a year number to that, but that is conduct that is very concerning.
All right. So moving on, terroristic threats, person or property?
Person.
All right. And so usually the way I see this is it's usually arising out of essentially some sort of a domestic type situation, that heat where somebody gets really mad and makes the threats. So just kind of to give context to others here. Any thoughts or comments on this one? I mean, it really is, for the most part, words. You're threatening it. It doesn't require the actual, let's say, presence of a weapon or anything like that. What are people's thoughts on terroristic threats?
Since the purpose of the threat is to terrorize someone else, I consider it a clear person issue. And even though, yeah, I see most, but certainly not by a long shot all of the terroristic threats together. I've also seen, terroristic threats against law enforcement, prosecutors, other public officials, and I take them very seriously, especially, after the retired judge in Wisconsin. So I think they're a real deal. They tend to escalate sometimes. So, yeah.
Okay, so fraud, I'm gonna move on. Fraud and obtaining credit. So obtaining personal credit or credit from another bank. I think we're back onto the fraud one. To me, I guess I understand it's a false representation or obtaining credit from a person, but to me, this is still a property crime. I guess
property crime.
And again, is this similar to the other, people feel strongly similar to the other fraud crimes or forgery crimes, excuse me, where I can see the concern when you're working with the funds of the population, but versus the actual care. What are people's thoughts? I'm seeing nodding heads, so I'm gonna go with that. Yes. Sorry everybody, I'm scrolling so that I can cut and paste. I'm gonna make it easy on myself. All right, so then 49, financial transaction and card fraud. Using somebody else's card, selling or transferring the card. So essentially that card use, this one's quite long, as you can see. It's a number of different parts to it. What is interesting to me is it does paragraph, or that subdivision 9 is specifically trafficking in SNAP benefits. So I guess this one to me is property with a little bit of crime of poverty mixed in there.
I agree.
Yeah. All right, and then I don't know, again, we're looking at that fraud type part of it. Anybody feel strongly, again, similar where those that are handling the funds, important documents that we've kind of been talking about for the other fraud ones? I'm seeing nodding heads. I'm gonna go for nodding heads. All right, indecent exposure not involving a minor. Willfully, lewdly exposes the body or private parts, engages in open or gross, lewd, or lascivious, I can't even say it right, behavior. So this is part of the obscenity statute, again, felony under certain circumstances. What are people's thoughts? Person, property,
Person,
other person? And then, and I don't remember off the top of my head, is this a registrable offense? Does anybody? I don't remember. Judge Kulik with your book.
do you want me to look up 1723?
If you don't mind,
I can do that. I've got my book.
because I feel like that might sort of help.
Okay, 61723. Look at this, indecent exposure, penalties. Felony requires multiple convictions, which is interesting.
So in other words, if you get here, you've got a problem, you've done it a few too many times.
Yeah, right.
If I'm going to put that sort of bluntly. Okay.
Yes, because there are misdemeanor, gross misdemeanor, or felony level, and felony is, yeah, you just keep on doing it. I do not see any reference to registration.
Okay. All right. And I guess knowing that it's somebody who has essentially, if for lack of a better word, kind of had their chance repeatedly, are people good with leaving this on our list for whatever time sort of scheme we ultimately come up with? But obviously this is somebody who multiple convictions did not learn that lesson.
I'm comfortable leaving it on.
Okay. And everybody, I promise we're almost there. I'm trying to get us done with this list by 5. So 51, obscene materials and performances. Again, I think this one is similar where you've got a repeat offender. It's also under the obscenity statute. So this is the selling, printing, publishing obscene materials. And this is the bad of the essentially obscene, where you're getting to that offensive conduct. It's conduct. It's not that artistic quality, if you will. So I guess person or property.
I could see it as a person.
Mm-hmm. Yeah. And again, this one we do have here, it's the repeat. So you've got your repeat offender. They're back multiple times.
I just want to say this. I saw this thing was I can't remember if it was like the what it was on, but even if it's not repeat offenders, any of that stuff that's obscene materials, like the children or the people that are in those materials, like they never get those pictures back. Like they are forever victimized by those pictures. And so like, just to keep that in mind, like, I don't like the repeat thing is one thing, but
this is actually a different crime from dissemination of pornography. Because, yeah, but I get your point.
No, yeah.
So what is obscene materials then?
Well, for instance, it's not without coming up with something outlandish. And if you don't mind, I'm going to give examples here of the sexual conduct. An act of sexual intercourse, normal or perverted, actual or simulated, including genital, anal genital, oral genital intercourse, whether between human beings, between a human being and an animal, sadomasochistic abuse, including flagellation, torture by or upon another person who is nude or clad in undergarments or in a sexually revealing costume, or the condition of being fettered, bound, or otherwise physically restricted on the part of one or so clothed or nude, masturbation, excretory functions, or lewd exhibition of the genitals, including any explicit close-up representation of a human genital organ. So does that give you a little flavor? I mean, it could literally be there's art, and then there's things that are created just for the value of, in a way, it's like sexually terrorizing someone because it is so offensive. So again, there's a misdemeanor or gross misdemeanor level, but repeat offenders, it rises to the level of a felony subject to imprisonment for up to 2 years, payment of a $10,000 fine.
So, and I think we only have 2 more, so we're almost there. So then we've got the ineligible person. So persons not to possess firearms. So this says somebody convicted with a crime of violence, committed as mentally ill, convicted of, let's see here, so it's convicted violation of the chapter 152, so the drug crimes, treatment facility. So essentially people who are not supposed to have the gun who have the gun. Person or property. I guess I'd say person. Any disagreement? Person, I see nodding heads. And I think what are people's, I mean, to me, I don't see an issue with this being on a disqualification list. I'm just curious if there's any sort of comments or thoughts or anything else surrounding this one. No? Okay, that's fine. One more, drugs, controlled substances. So this is your chapter 152. I think this was the one my law clerk warned me was difficult for him because by the statute, it kind of lists a bunch right together. So person or property for the drugs.
Well, I don't, this is hard. It involves a person, but the only one you're hurting is yes, we like to say the community is the victim here, but the trouble I've always had with the felony controlled substance crimes is I don't see a breakdown. I don't see a difference at felony level between a first degree and a fifth degree. And there is, of course, a huge difference there. Fifth degree felonies are not selling. They are, you have a substance abuse disorder. And I am very much against a 15-year disqualification because there are so many great people who have years of recovery, a lot of great insight, have educated themselves. They would be the perfect people to get an LADC license, and they're prohibited. It's one of the largest areas of frustration I have.
I would suggest that this category, and I know we're trying to draw some clear guidelines, but this category is almost a category unto its own, given how different it can be from sale or distribution, and based on the amount, based on a person's amenability to correct those conditions, and given how much or how disparately the statute is even applied, I think, in the state. And so I think this one just bears further conversation when we're assigning it a level of danger to the population they'll be working with.
I agree with Ms.
Yeah. Gina, I know you've talked quite a bit about, I think this one you were, do you want me to pick on you as Chair Geffen always says, or should we kind of just go with Max, leave it with Max, that it definitely is a further conversation? She might not be there.
I'm going to volunteer to jump in.
Thank you.
So I can pick up a newspaper and read a headline about a drug bust where somebody maybe has a gun, maybe they don't, they living in terrible conditions, maybe they have children in the house, they're selling to people they don't know, their connections are to nefarious people, and I'll look at that and say those people ought to be locked up. I have a drug felony for possession and intent to distribute. And I got started by buying it for myself, getting tired of sitting and waiting on a stupid drug dealer to buy $100 worth of cocaine. And this, by the way, was when I was holding a $350,000 a year job. I decided I would go buy an ounce, which would put me in a bad category. And then all my friends who are family people, many of whom have children, wanted to use what, I hate this term, but socially use on the weekend. They would say, why should they go find a drug dealer? Dave has it. And they would come to me and say, can I get it from you? And I had it. So that was the extent of my dealing, was selling to my family friends. Doesn't make what I did right. I'm accountable. I served my time. Believe me, I've had lots of penalties, both obvious ones and unintended consequences that come from committing a crime like that. Since then, I've raised kids who I think are great kids, good people in society. They have college degrees. I have a great relationship with my wife. I'm a senior vice president where I work. And I didn't pass the background check when I initially went through it. I agree with what Max said. This is, and I don't want it to be about me, but I just think there's two totally different things that can happen when you arrest somebody in a controlled substance crime. And you need, when I went through court, they did a background check on me, a pretrial background check. They find out what kind of person you were and what happened. And I think having that kind of discretion for DHS would be important, because many things could be different at the time of the arrest. And then for me, subsequent to my arrest and before I started at Teen Challenge, I spent several years speaking to college students, high school students, businesses, Rotary groups. So what do you do with your life after you commit the crime? I think that's important to weigh in as well. And Judge, I know you get these kinds of differences. Actually, I asked for probation and I had a female judge and she said, Ms. Irvin, you're not the typical person I see in my drug court. And I've gotten lots of references from schools, from people that you taught, people that you coach. I would love to send you back out into the community to do good works. However, I can't give you a pass when somebody less fortunate won't get a pass. And so I got sentenced to prison time. I think the consequences rest with the court. I think when you have a background check, the people at DHS ought to be able to look at more than just your crime on a list and automatically disqualify you. And I'm fortunate, I don't even consider going to Teen Challenge anymore work. I'm doing service. And I get to do that because I was able to get a set aside, not because the law allowed for it. So I do think, Max, you're right on point. This you could spend a lot of committee time on controlled substance, and then how you apply it. It might be different for Ms. Kaser with foster situations than it is in mine, where I'm dealing with people who are going through substance use therapy, and to bring in somebody who's lived it might be a great spot for these people to go to work. So I think it does beg more time. For right now, I don't think it should be on a 15 or a permanent disqualifier at all. And I obviously feel strongly about that.
Oh, and I thank you for sharing. I definitely think that, these lived experiences and these personal experiences are so helpful, and it's helpful for everybody to understand how they're applied and who they affect. So I
just want to say goodbye. So sorry to interrupt, but
Yeah.
I will see you all at the next meeting.
All right, sounds good. So I do see that we're at 5 o'clock. What I was going to propose, really based on Max's comments and Dave's comments, is we are scheduled for next week. My proposal would be that maybe we spend, since we're gonna have an hour, spend the first 30 minutes really talking more about this particular, the drugs and the controlled substances. And then from there, I think spend the remaining 30 minutes, especially now that we've done this deep dive into all of the felony level offenses, to really start formulating, because based on some of these conversations, I'm trying to decide how deep we need to go into the gross misdemeanor and misdemeanor, or if it makes sense really based on what we have all learned from these felony offenses. If we can maybe use the second half next week to start really thinking about, now that we know this much, are we at a point where we can start thinking kind of big picture about, for example, the time scheme, what types of crimes, persons, property, how should they be applied? And even if they're 10,000 foot kind of that global view, but sort of if we're at a point where we can start thinking about some of those recommendations, and then if we feel we need to dive into the gross misdemeanor and misdemeanor, we definitely can. But I guess, are people good with that? Just sort of a plan of attack for next week? Perfect. I see a thumbs up. I see nodding. All right. And Will, if you wouldn't mind, obviously just making a note of that plan for next week, so that if I can't be here, everybody knows I'm scheduled for, so everybody knows I'm scheduled for an evidentiary hearing next Tuesday afternoon. So if I can't get here in time, Gina's going to lead. So that way, then we've got a plan for next week, and if I can be here, great, or I'll be late. And then otherwise it'll be Gina. All right. Well, thank you, everybody. Thank you for staying here a few minutes after, and everybody enjoy your day. Stay cool.
Thanks, Lucas.
Thank you.